or who may not be qualified to vote for whatever reason, or who may have already voted but wants to vote a second time is not doing so. I yield back.
Gentleman yields back. For what purpose does the gentleman from Virginia, the chairman, rise?
I rise in opposition to the amendment.
Gentleman is recognized for 5 minutes.
I was the only member of the Virginia delegation to vote for the Voting Rights Act in 1982. I attended school for 1 year in a state that I saw things that were different than I had seen before. And there's a Simon & Garfunkel song, The Boxer, that man hears what he wants to hear and disregards the rest. We really can't disregard what has taken place in the country. Now, we may be reaching a point that this should be looked at again. My state, I believe there is no discrimination now in my state. I think the Judiciary Committee ought to look at this carefully, but this is not the place to do this, and it is such a sensitive issue. Section 5 of the Voting Rights Act applies to jurisdictions determined to have had a history of discriminating against minority voters. Section 5 requires certain covered jurisdictions based on a formula set forth in Section 4 to pre-clear their congressional redistricting plans with either the Department of Justice or the U.S. Department Court for the District of Columbia before implementation. In order to be granted pre-clearance, the jurisdiction has the burden of proving that the proposed voting change neither has the purpose nor will have the effect of denying or abridging the right to vote on account of race or color or membership in a language minority group. Litigation is pending now in the Federal District Court, including the case of Texas versus Holder, that challenges the constitutionality of the coverage formula and pre-clearance requirements in Section 4 and 5. In its 2009 decision, Northwest Austin Municipal Utility District No. 1 versus Holder, the Supreme Court may have signaled a willingness to reconsider the constitutionality of the pre-clearance regime and coverage formula. But this is not an amendment that I think is appropriate here. And again, as we deal with this thing, we have to be very, very sensitive because, quite frankly, I remember in 1982 when I voted for this, there were editorials in the Richmond Times-Dispatch ripping me apart for this vote. But because I do believe that everyone should have the right to vote, I voted for it. But I would also say to end, we may be approaching a time that this would go, because we want a nation where no one is discriminated against. We may have reached that point, but I think the Judiciary Committee should hold extensive hearings. We should see what the support of the Supreme Court does, but I think this is not the place to do it, and so I strongly rise in opposition to the amendment. Yeah, yield.
I'd like to ask the chairman if he would yield.
Excuse me?
Would you yield?
Yes.
I thank the gentleman for yielding, and I've enjoyed a great relationship with the gentleman during his tenure in the Congress. You mentioned several times in your remarks that there might be an appropriate time. How do you objectively determine when there is an appropriate time for not extending Section 5 to the covered jurisdictions?
I am not the legal scholar, and at 10 after 10, I don't think I can do, but there may be a time. I believe now in my state, I believe there is not discrimination with regard to voting. I think our governor is a good, decent guy, and I don't think wants to discriminate against anybody. The members of the General Assembly are of that same mind. Yet there had been in a case in previous times in the state of Virginia. So I'm not going to be the I went to Georgetown Law School. It's an accredited law school, but I'm not going to get here tonight and sort of lay it out. I think we have a Georgetown graduate there. But I don't think this is what we ought to do tonight. And I initially wasn't going to speak, but I just feel strongly. And again, I go back. I remember in 1982 voting for this, and people felt it, and I just felt in my heart this was the right thing to do. As of now, in my heart, it tells me we ought not adopt this amendment, and we can see the Judiciary Committee can hold hearings, and both in the House and the Senate, we can see what the Supreme Court is doing. But I just don't think this amendment is this is the place, and I strongly, and I reclaim my time, I strongly oppose the amendment, and yield back to Bill.
Gentleman yields back.
Mr. Chairman,
For purposes, gentleman from Georgia
I
rise.
move to strike the last word.
Gentleman is recognized for 5 minutes.
Now, it is hard and difficult and almost unbelievable that any member, but especially a member from the state of Georgia, will come and offer such amendment. There's a long history in our country, especially in the 11 states of the old Confederacy, from Virginia to Texas, a discrimination based on race, on color. Maybe some of us need to study a little contemporary history dealing with the question of voting rights. Just think, before the Voting Rights Act of 1965, it was almost impossible for many people in the state of Georgia, in Alabama, in Virginia, in Texas, to register to vote, to participate in the democratic process. The state of Mississippi, for an example, had a black voting age population of more than 450,000, and only about 16,000 were registered to vote. One county in Alabama, the county was more than 80%, and not a single registered African-American voter. People had to pass a so-called literacy test. Interpreting section of the Constitution, one man was asked to count the number of bubbles in a bar of soap. Another man was asked to count the number of jelly beans on a jar. It's shameful that you would come here tonight and said to the Department of Justice that you must not use 1 penny, 1 cent, 1 dime, $1 to carry out the mandate of Section 5 of the Voting Rights Act. We should be opening up the political process and letting all of our citizens come in and participate. People dying for the right to vote. Friends of mine, colleagues of mine. I speak out against this amendment. It doesn't have a place. I agree with the chairman. This is not the place.
Gentleman
I
yield.
urge all of my colleagues, no, I will not yield, to vote against this amendment.
Gentleman yields back.
Mr. Chairman.
For purpose does the gentleman from Illinois rise.
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, let me first associate myself with the remarks of the distinguished gentleman from Georgia, Mr. Lewis, who paid the price for this Voting Rights Act, the Voting Rights Act of 1965, on the Edmund Pettus Bridge. He paid beyond measure. He sacrificed beyond measure to make this a reality for every American. This near-midnight attack is an unprecedented attack on the implementation legislation of the 15th Amendment to the Constitution, the 1965 Voting Rights Act. It took this Congress 95 years from the moment that the 15th Amendment was added to the Constitution of the United States for this Congress to wake up after Selma to Montgomery to pass legislation to implement the Voting Rights Act. For me to stand here and listen to my distinguished colleague, the distinguished gentleman from Virginia, the chairman of the subcommittee, for him to argue that there may be a time, and we may be approaching a time, when the Voting Rights Act preclearance provision of Section 5 is no longer necessary, couldn't be further from the truth. Here's how the state legislative process works within most state legislatures. First, whoever's in the political majority, Democrat or Republican, usually draws legislative lines consistent with their political advantage, whether it's the Democratic Party or whether it is the Republican Party. Such is the case in Illinois. Such is the case of every state in the Union. Almost never before the 1965 Voting Rights Act had racial minorities or language minorities ever been considered as a factor in the ongoing partisan debate for the last 150 years between Democrats and Republicans. Only the Voting Rights Act of 1965 says that if a language minority or a racial minority in a protected jurisdiction can draw a congressional district or can draw a state representative district or can draw a state senatorial district to give a racial minority an opportunity to represent their own people in a legislative body, the state legislative body must take that into account. And for us to be standing here on the floor of the Congress arguing about the right to vote, we're not discussing at that level the right to vote. We're discussing whether or not legislators will be effective in representing their constituents by protecting Section 5, the preclearance provision, because most of us can't go to our governors or our state legislatures to protect the franchise for minorities. I know that the 1st Congressional District, the 2nd Congressional District, the 7th Congressional District, the 4th Congressional District of Illinois are all Section 2 of the Voting Rights Act congressional districts. From Virginia around to Texas, because we still cannot trust Democrats, because we still cannot trust Republicans in Virginia, all the way around to Texas, to consider racial minorities in the drawing of congressional districts, sure, those states must implement their plans by submitting their plans to the federal government for preclearance. Look at the language minorities. Look at what's taking place in Texas. Look at what's taking place in New Mexico. New Mexico, a state 25% Latino. And the state legislature played games with what constitutes an effective congressional district that might give a Latino an opportunity to represent a congressional district in Congress. It plays both sides against the middle. Both Democrats and Republicans through history, Mr. Speaker, have used race as a partisan advantage in trying to draw congressional districts and legislative districts. I appeal to you, Mr. Speaker, to reject this amendment at midnight, reject this unconstitutional, unprecedented attack on the civil rights of every American, reject efforts to undermine the implementation legislation of the 15th Amendment, earned through an American Civil War along with number 13, 14, and 15, reject this effort to roll back the civil rights gains of 1965 by undermining the funding and the federal government's capacity to ensure that minorities have a chance to represent themselves in the Congress of the United States. Reject this effort on this evening. Both Democrat and Republican should reject it in a bipartisan manner. And with that, Mr. Speaker, I know the gentleman is going to strike the last word with his own time, but I want to give him the last minute I have in addition to striking the last word on his own time. Is the gentleman okay? Mr. Lewis, would you like to add something else? Mr. Speaker, I return the balance of my time.
Gentleman yields back the balance of his time. For what purpose does the gentleman from California rise? Does the gentleman seek to strike the last word? Gentleman is recognized for 5 minutes.
Mr. Chairman, one of the proudest moments of my experience here in the House is to work on a bipartisan basis to the extension of the Voting Rights Act in the 1980s. I have been involved in the extension of the Voting Rights Act in this several Congresses ago. But also as Attorney General of the State of California, I was involved in the pre-clearance procedures by the Justice Department with several of the jurisdictions in my home state. The Voting Rights Act has stood as one of the great efforts at progress in this country. But as the U.S. Supreme Court said as it reviewed the preclearance requirement some years ago, there will come a time when this unprecedented power of the federal government versus the sovereignty of the states will end. The preclearance requirement contained in the Voting Rights Act is an anomaly, a necessary anomaly over history, but it is an anomaly. And we should understand that the court viewed it as such. The problem I have with the current status of the Voting Rights Act is it gives no opportunity for an escape clause by those jurisdictions that have proven over the decades that they have, in fact, changed their practices. There is no means by which a jurisdiction can come forward and show that over a decade they have not, in fact, discriminated, but have acted appropriately, and therefore this tremendous Justice Department authority will be no more there. But This is not the place to deal with it, I would say. A funding resolution is not the place to deal with it. This is an important issue that ought to be addressed, and I would hope that my friends on the other side of the aisle would recognize that when you have a jurisdiction that has for 10, 20, 30, 40 years followed the law, perhaps we ought to reward them and provide incentives for other jurisdictions to do the same. Also, historically, there is a reason, almost a historical accident by which some of the jurisdictions in California are covered. It had to do with a low turnout election in which a large percentage of the people who were considered as citizens happened to be military folks who didn't vote in that area in that particular election. And there's been a static analysis which has resulted in those jurisdictions to be continued to be covered under that section of the law which allows this unprecedented authority of the Justice Department to pre-clear. And I would hope that we would have the courage to stand up and look at the changes that have taken place and give credit to the consensus of conscience of civil rights that I think has prevailed in this country and has aided us greatly. But I would just say this is not the time nor the place for us to, within a short period of time on the floor of the House, try and make a significant change in that. And therefore, with all due respect to my friend from Georgia who points out some of the problems here, I would have to oppose this amendment. But I would hope that we would have the courage to come to this floor and recognize that changes may be necessary, and this is an unprecedented authority that is granted to the Justice Department. No other jurisdictions are required to come before the Justice Department and ask their permission as to whether they make a change as simple as changing a date or making any change with respect to any election process in that jurisdiction. So I hope my friends on the other side who have, I think, appropriately opposed the gentleman's amendment would also recognize that there is a large area in which we should discuss the current status vis-a-vis the current fact situations that exist with all jurisdictions. Let us hope that as bad as conduct has been in the past, that we believe in redemption, and that we believe that there can be changed hearts, and we believe that we can change practices, and that we believe that, in fact, maybe the goodwill of our fellow citizens will prevail. And when it has done so, let us recognize that, give them credit for it, and in the law provide incentives for other jurisdictions to also change their ways. So with that, Mr. Chairman, I would yield back the balance of time, asking that we not support this amendment, but at the same time recognizing the legitimacy of the shortcomings of the law as applied currently and the failure of the Congress to make changes to give credit to those jurisdictions that have, in fact, acted in good faith.
The gentleman yields back. For purposes, the gentleman from Pennsylvania rise.
I rise to strike the last word, and I'll be glad to yield to my friend in 1 second. Let me just make a couple of comments. I think that, we've seen why this is not the process for these types of riders on a bill. In states that are not covered by Section 5, there have been outrageous circumstances as it relates to particularly African Americans and access to the franchise. In Philadelphia, Octavius Cato was beaten to death just a few blocks from the home of my childhood when he tried to exercise his right to vote. But our country has come a long way. We've made a lot of progress. But Section 5 is there for a reason. In these states in the South, Nazi prisoners of war were treated better than African Americans who had served in the war. For the party of Lincoln to be on the floor of the House today on this issue when it was really Republicans that had joined in the passage of the Voting Rights Act, when members of my party refused to be willing to grant these rights to African Americans and to others, I think is unfortunate. But I think we may be at a point when we can move forward. I want to yield to my friend. We're going to be in worship together tomorrow morning at 8 a.m. I yield to you.
Thank you. I apologize to my dear friend from Georgia if he's gotten angry with this amendment, and it's never my intent to do so, and I'm going to ask unanimous consent to withdraw the amendment. I deplore discrimination of any kind. As far as I'm concerned, I believe in the Bible. I think it's the only standard of truth that we have. As far as I'm concerned, there's only one race of people. It's the human race, because we all came from Adam and Eve. And no one should be discriminated for any reason. I have the same dream that Martin Luther King had, where people are accepted for their character and not any discrimination against their skin or their forefathers or anything else. And any insinuation that I would ever believe in any kind of discrimination or trying to suppress anyone from having their constitutionally given rights, I detest that accusation, frankly.
The hour is late. I want to reclaim my time. I want to thank you for withdrawing your amendment, and I thank the chairman for his previous statements in this regard.
Well, I apologize to any hurt feelings that anyone has, because I certainly wasn't meaning to try to hurt anybody's feelings. But we've got to come to a point where...
I reclaim my time. I thank you very much.
Gentleman from Pennsylvania yields back the balance of his time. The gentleman from Georgia is seeking recognition of withdrawal.
Yes, sir. I ask unanimous consent to withdraw my amendment.
Without an objection, so ordered. The amendment is withdrawn. For what purpose does the gentleman from Kansas rise?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
He's got 224
Would the gentleman specify which amendment?
I believe the amendment is in the congressional record is number 24, Mr. Chairman.
The clerk will designate the amendment.
Amendment number 24, printed in the congressional record, offered by Mr. Holzkamp of Kansas.
The gentleman from Kansas is recognized for 5 minutes.
Thank you, Mr. Chairman. I know the hour is late, but I felt called to offer this amendment as I think many of us believe our nation is not a nation of men, it's a nation of laws. What a Congress passes and a president of any party signs into law, Mr. Chairman, is the law of the land. And if a new president or a new attorney general does not like an existing law when they come into office, it's not his or her prerogative to decide whether or not to enforce a particular law. It is his or her constitutional obligation to defend it. But somehow, Mr. Chairman, I'm sorry to say this fact is lost on the current administration. In a very clear and flagrant violation of its responsibilities, the U.S. Department of Justice, under the direction of Attorney General Eric Holder, and with the blessing of the President, have decided not to enforce the Defense of Marriage Act, which has been the law of the land since Joe Biden voted for it in 1996, and it was signed into law by President Bill Clinton. And tonight, I'm offering an amendment to prohibit the Department of Justice from spending taxpayer money to undermine the Defense of Marriage Act and stop the Department of Justice from ultimately undermining the rule of law. As many of us know, just last night, the 30th state actually passed an amendment to amend its constitution to protect traditional marriage. That would be the state of North Carolina. And in my opinion, it likely becomes an easy target for the administration. My amendment would also prevent the Department of Justice from interfering in North Carolina or any other state over its marriage amendments and marriage laws. Let me read. We have 30 states that have marriage amendments. It would be states of Alaska, Nevada, Mississippi, Missouri, Montana, Oregon, Colorado, Tennessee, Arizona, California, Nebraska, Arkansas, Georgia, Kentucky, Louisiana, North Dakota, Ohio, Oklahoma, Utah, Texas, my favorite state, Kansas, Alabama, Idaho, South Carolina, South Dakota, Wisconsin, Florida, North Carolina, Michigan, and Virginia. Each of these states, or actually the population of each of these states, the citizens passed a marriage amendment to define marriage as they saw fit, and this amendment would protect those definitions from any contribution by this department. The Department of Justice and the President of the United States do not have to agree with the law, Mr. Chairman, but they certainly have to enforce it and respect it. Even though I believe it would be in their political best interest to do so, 30 states have constitutional amendments, again, defining marriages between one man and one woman we have current officials of this administration have expressed their political preferences against traditional marriage and against the Defense of Marriage Act, against various marriage amendments. But whatever the platform contains, whatever the personal preferences are, unless those laws are changed, unless those amendments are repealed by the people of these states, they stand and remain the law of their states and remain the law of the land. It would also, it's clearly, in my opinion, the administration is turning the Justice Department into a legal mouthpiece for its campaign rather than its purpose to enforce the law. Most concerning is the fact that in turning the Justice Department into an instrument for legislating political favors rather than enforcing the rule of law, this becomes the Department of Politics, in my opinion, not the Department of Justice. So, Mr. Chairman, I urge my colleagues to support this amendment, support the folks of 30 states, the citizens who have made decisions, and also the citizens of 50 states that have passed their marriage laws. These are protected under the Defense of Marriage Act from contravention by those of us in Washington. And so with that, I yield back the balance of my time and encourage...
The gentleman yields back the balance of his time. For what purpose does the gentleman from Massachusetts rise?
To strike the requisite number of words.
The gentleman is recognized for 5 minutes.
Mr. Chairman, to begin, I have read this amendment, and if it were to be law in an hour, it does not appear that it would affect anything that's now happening in the federal government. The gentleman said that they were trying to undermine the act and that they should enforce it. In fact, the administration has been very clear. While they disagreed with the act, they would like it repealed. They, in fact, believe it's unconstitutional. It is now on the books, and nothing is being done in contravention of the Defense of Marriage Act. That is, there are no things now going on where the federal government recognizes the rights of same-sex marriage. So I guess my main opposition to this is that the bill's already big enough. This doesn't add a lot, but it doesn't add anything in substance. It adds a few words. So if someone, I would yield if anyone could tell me what the reference is to their not enforcing the act. Now, it is true the administration declined to defend the act in court, but not defending an act in court in no way means that you are contravening it in the enforcement. Going to court is a different story. As a matter of fact, the House Republican leadership has voted to go to court to defend it. So I again would be glad if someone would tell me the Defense of Marriage Act says the federal government will grant no rights to same-sex married couples that come from marriage. It's not doing that. I agree, the administration doesn't like that, but the suggestion that they are undermining the law is simply wrong. Now, I understand, and this may be the confusion, that the gentleman originally planned to offer a different amendment. And that amendment, he was told, was not in order. And maybe he changed the amendment and somebody forgot to change the speech, because the speech he gave may apply to the earlier amendment, but it doesn't apply to this one. So it seems to me kind of a waste at the late evening, but you know what the heck, the evening's shot anyway. It does not say the administration shouldn't go to court. That is not contravening the Defense of Marriage Act. Contravening the Defense of Marriage Act would be extending benefits. And I want to reassure the gentleman, when I get married in July to Jim, I will not be looking for any federal benefits. He wouldn't be eligible for my pension even if I got one. I won't get one, but he wouldn't be eligible if I got one. I am very familiar with this. And in fact, nothing being done now by the federal government nor contemplated by this administration contravenes the Defense of Marriage Act. What the administration has said is we think it's unconstitutional and we're going to oppose it. Now, I know there are some who say, not the gentleman from Kansas, I agree, he didn't say that. Some have said, well, how dare you ask the court to throw out a law passed by Congress? You've heard that rhetoric. After all, Congress passed this law. How does the court dare to overthrow it? Well, that's an argument I used to hear from my conservative friends a lot more before the health care bill came up. So let's be clear. There are now two major pieces of legislation passed by this Congress, not this particular one, that are being contested, and people are asking the U.S. Supreme Court to throw them out. One's the Defense of Marriage Act, one's the health care bill. You can be against, in principle, the courts throwing out an act of Congress as unconstitutional. You can be for it in principle and differ as to the application. But there isn't any way that you can say it is perfectly legitimate to cancel the health care bill through judicial intervention, but not to challenge the Defense of Marriage Act. So I actually, I assume they're going to want a roll call because they went through all this effort. They'd like to be able to have this to talk about in campaigns. It literally means nothing because there is no contravention going on now. So I will be glad to vote against it. If other people vote for it, they can do so in the confidence. And it doesn't mean, again, the Defense of Marriage Act says you don't grant benefits to same-sex couples as if they were married. Nobody's doing that. That isn't happening. It isn't planned. It won't happen until and unless the Supreme Court finds unconstitutionality. And refusing to defend an act in court in the English language is not contravention. As a matter of fact, it says none of the funds made available may be used in contravention. Well, not going to court is not using funds. Maybe he meant to say none of the funds under this act may be not used in contravention, because they certainly aren't spending any money by not spending any money. So maybe he meant to say they should spend the money, so I don't know. But it is, I understand his original intention was ruled out of order. He had a place in the agenda, so he offered an amendment, but it doesn't mean very much. I yield back.
The gentleman yields back. For what purpose does the gentleman from New York rise?
Mr. Speaker, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Speaker, I had anticipated, and we had been told that the gentleman was going to offer an amendment that said none of the funds in this act may be used by the Justice Department to argue against the Defense of Marriage Act, to argue for the Defense of Marriage Act in court. And I was going to object on the same grounds that I have in some other such amendments earlier today, that we should not be politicizing the Justice Department. We should not be telling them, do defend this in court, don't defend that in court. But as the gentleman from Massachusetts says, this amendment seems to do nothing at all. None of the funds made available under this act may be used in contravention of the Defense of Marriage Act. Well, none of the funds are being used in contravention of the Defense of Marriage Act. The only circumstance I can envision under which funds might be used in contravention of the Defense of Marriage Act would be after the Supreme Court declared the Defense of Marriage Act unconstitutional. If the court declared the Defense of Marriage Act unconstitutional, then the Constitution, frankly, would demand, under the Equal Protection Clause, that funds be spent against the will of what had been the Defense of Marriage Act. If the Defense of Marriage Act is unconstitutional, then someone will, who is married under the laws of the state, some state that permits same-sex marriage, will demand to have joint filing of income taxes, or will demand the tax benefits that a spouse gets, and it would be unconstitutional not to grant that. So this amendment is frankly silly and shouldn't clutter the statute books, because until and unless the Defense of Marriage Act is declared unconstitutional, it means nothing. And once the Defense of Marriage Act is declared unconstitutional, if it is, then this itself would be unconstitutional as against the Equal Protection Clause. So I urge people to vote against it because, one, we shouldn't pass meaningless statutes, which this is or would be, unless DOMA is declared unconstitutional, and we shouldn't pass clearly unconstitutional statutes, which this would be if DOMA is declared unconstitutional. So it is either meaningless and unnecessary in the one case or unconstitutional in the other, and frankly ought to be withdrawn, but certainly should not be voted for. And so I urge my colleagues not to vote for this, whatever you think of DOMA, frankly. Because if DOMA is constitutional, this is unnecessary, this is unconstitutional, and if it's not, I'm sorry, if DOMA is declared unconstitutional, this would be unconstitutional, and if it's not, it's unnecessary and has no effect in any event. So I don't know what the point of wasting our time with it is, but we should oppose it. I yield back.
Gentleman yields back. For what purpose does the gentleman from Colorado rise?
Mr. Chairman, I request to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. This is a very strange amendment, as my colleagues have pointed out. We are obviously a very diverse country. Some states allow same-sex marriages. Other states do not. Some have civil unions. My home state of Colorado is currently discussing this issue in the state legislature. It's certainly very contentious, and I wish them well in coming to a speedy resolution. But what this amendment does is simply contravene something that doesn't occur. It talks about funds being used in contravention to the Defense of Marriage Act. There are no such funds. This administration, as the last administration, have followed the Defense of Marriage Act. I certainly, out of political convenience, I would say would that it were, if only this administration had been granting immigration rights or inheritance and survivorship rights to committed same-sex couples that were married in the states that have them, but it's simply not the case. Now, I understand that there might be fears that perhaps someday a future administration might seek to violate the law in this area, but I think it shows a fixation to try to single out this area. I mean, a future administration or any administration might try to violate the law in any one of a number of areas, but to have a fixation on and support for a government takeover of the institution of marriage is a very dangerous precedent. And I wish that my colleagues on the other side of the aisle would help preserve the integrity of marriage in this country and its importance to all families, including mine and my colleague from Massachusetts and many others. We do not currently use any funds in contravention of the Defense of Marriage Act. There are a number of us in this body who seek to repeal this act. This House as a whole has not repealed this act. It very much has the rule of law. But just like other laws, the administration and the executive branch are charged with implementing that law. And I think it is a bizarre step to single out one particular area of law with many, many, many laws that the executive branch operates under and say, we don't want them to violate this law, when there is, of course, no evidence, no sign, no indication that any administration, Democratic or Republican, has any desire to violate this law. The decision not to defend this law is unaffected by this amendment. And to be clear, if this amendment passes, the administration has no bearing on the administration's decision not to defend the undefendable, namely the government takeover of marriage that my colleagues on the other side of the aisle seem to support. Marriage is a very personal relationship between two people who are in love. And of course its precise definition is up to each state in terms of who they allow and under what conditions they allow to marry. And to have the federal government enter this debate is very contrary to the definition of marriage itself, and frankly debases the thousands of same-sex marriages that have occurred in this country. So again, while this amendment would do nothing, and certainly wouldn't jeopardize the administration's decision not to defend the undefensible, namely the government takeover of marriage, I still urge opposition to this measure because I think it is bizarre to single out one particular area or one particular type of marriage that some members of this body may not personally approve of. I yield back the balance of my time.
Gentleman yields back. For what purpose does the gentleman from Iowa rise?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in support of the Huelskamp amendment, and you know, I listened to the gentleman from Colorado say at least 3 times a government takeover of marriage. Yes, the faith in the church and the churches have been the ones who have established marriage over the centuries and over the millennia, but when it comes to civil marriage, the government writes the rules. If the government's writing the rules, it's not a takeover of marriage. The definition of marriage from the beginning of time has been a man and woman joined together, hopefully in holy matrimony, for the purposes of encouraging a family unit and raising children and pouring our values down through that crucible of marriage into the next generation, because that's the most successful and effective way that we can advance the civilization. The government has an interest in promoting marriage for the purposes of holding together the continuity of our culture and our civilization. It's not a nefarious thing. It's not the government taking over marriage. It is the voice of the American culture and the American people seeking to advance into the following generations the best values that we have. And those that say that it's a discrimination to determine what marriage is, I would argue instead, Mr. Chairman, that the government provides a license. The states provide licenses for marriage. A license is a definition to do that which is otherwise illegal. A license to hunt, a license to carry a gun, a license to fish, for example. I'll finish my statement. If I have time, I will yield to the gentleman from Colorado. But the states issue marriage licenses because they want to promote and encourage an activity and a behavior, not because they want to punish another behavior. It's because there's something that they have determined has value, and so they give a permit to do that which is otherwise illegal, and that's what a definition of a license is. And with regard to the President and the executive branch, the Constitution and the oath that's implied in the Constitution, the oath that the President takes that is implied that he adheres to in the Constitution says, he shall take care that the laws are faithfully executed. And so the law of the United States is DOMA, the Defense of Marriage Act. The President's obligation and his appointees and all of the elected in the executive branch of government is to take care that the laws are faithfully executed. The appointments of the President and the branches in the executive branch are bound by his oath, and they take their own oath to uphold this Constitution. And when the President of the United States decides he's going to flip on his position or maybe let it evolve into a condition and then direct, and I believe it is direct, the Department of Justice to first refuse to support and have the Solicitor General no longer support federal law passed by a majority of this Congress, the House and the Senate, and signed by President Clinton, and then turn around and now we're concerned that they're going to use taxpayers' resources to defy a legitimate law that is the will of the people and on the books in the Federal Register. And that's what the amendment does that Mr. Huelskamp has offered. It says it's bad enough that you don't keep your oath to take care that the laws of the United States are faithfully executed, and we want to say to you, don't at least turn a 180 on us and go against the will of the American people and use taxpayers' dollars to work against the will of the American people, against your oath to the office, and against the statute. So out of courtesy, I would yield to the gentleman from Colorado.
I thank the gentleman from Iowa, and just for a brief question, the gentleman's home state of Iowa does allow same-sex couples to marry, and I would just like to ask, in reference to the first part of your remarks, whether your home state of Iowa, in any way, shape, or form, whether civilization is in jeopardy, or were any of the things that you mentioned in the earlier part of your remarks have, in fact, hurt your home state of Iowa.
In reclaiming my time, yes, civilization is in jeopardy. It's in jeopardy when you have 7 Supreme Court justices in the state of Iowa who declare that they have found rights in the Constitution that were up to this point, and I quote, unimagined. If you have justices that find unimagined rights in the Constitution, they are completely unqualified to legislate from the bench or determine what's constitutional and what's unconstitutional. And 3 of the 7 were up for a retention ballot a year ago last November, and they were all 3 voted off the bench, the first time in the history of the state, partly because people disagreed with the policy they sought to impose by legislating from the bench, mostly because the people in the state understood that you cannot have judges that will find rights in the Constitution that were up to this point unimagined. Judges that can imagine rights in the Constitution will take your rights away. A president that will change his position, that will not uphold his oath of office to take care that the laws are faithfully executed, that will direct the Department of Justice to work against this, and the Solicitor General to work against federal law, will turn this thing 180 and use the federal resources against the will of the people of the United States. And that's the Huelskamp Amendment, and I support it. Thank you, and I yield back.
Gentleman's time has expired.
Mr. Chairman.
For what purpose does the gentleman from Ohio, member of the committee, rise?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I didn't plan to speak on this amendment, but I have to tell you I find it to be an unfortunate amendment. I find it to be an unfortunate amendment not for what some people may suspect. I was here for the Defense of Marriage Act. I supported the Defense of Marriage Act. I believe the Defense of Marriage Act is constitutional. But this amendment is symptomatic of what I think the problem of this Congress has been since it convened last January. And that is first the CR and then some other bills and now the appropriations bills. Some folks have decided that they should just be a piñata filled with all kinds of extraneous issues that have nothing to do with the core mission. This issue that is the subject of this amendment, I would tell the author, who was not here when DOMA was passed, is being resolved. The Justice Department, I think wrongly, made a decision not to defend the lawsuit, but as Mr. Nadler said on a previous amendment, and I commend him for saying it, that's the executive's prerogative. But once they make that decision, the Congress is not powerless. And the Congress has taken action. And so the committee that exists here in the House voted to employ outside counsel. Outside counsel is vigorously defending the House's position in the Defense of Marriage Act I think there's 30 lawsuits across the country. This matter will be resolved. And the courts will either say that it's constitutional or unconstitutional, and then we will all abide by that decision. Now, where I find fault with my Democratic friends is that we've had a couple of markups in legislative branch, and they're all exercised about the money that is costing us for outside counsel. Well, you can't have it both ways. Either the administration is going to defend it through the Justice Department, or we're going to avail ourselves of our constitutional responsibilities, hire outside counsel, so you can't criticize the Speaker for paying a lawyer to defend our position. And likewise, I would suggest to my side of the aisle that this doesn't belong on Mr. Wolf's bill. There is not a problem. This matter will be resolved. It is being resolved. And I think that this entire string of limitation amendments are disturbing because they continue a pattern now that's gone on for 18 months, and I don't think that's what an open rule is all about. I yield back my time.
The gentleman yields back the balance of his time. For what purpose does the gentlelady from Texas rise?
I ask to strike the requisite number of words.
The gentlelady is recognized for 5 minutes.
Well, I thank the distinguished chairman, and I thank the distinguished gentleman from Ohio that just spoke on the floor of the House. He's an appropriator, and he sees this litany of limitations as being challenging. I know that members are probably drafting some more limitations as we speak, and I certainly respect their prerogative. But I would just add this point as I listen to my good friend from Iowa, who I know is certainly a civil libertarian and believes in individual rights, and I would imagine the proponent of this amendment does as well. And I would ask the proponent of the amendment, as he has listened to the debate, to simply withdraw the amendment. There are several factors that would contribute to that. One, the query that was made by the gentleman from Massachusetts is whether the amendment even does anything. But as well, if we look at the 10th Amendment, which my friends on the other side of the aisle have always paraded before us, and that matters, even though there's a federal law, the DOMA law, that there are matters should be left to the state. And as recounted by the gentleman from Colorado, there are many different positions on this issue throughout the state, throughout the different states. Some have positions, some do not. Now we have a bill, or an amendment rather, that simply seems to deal with actions stated by the executive on this very day. My friend from Iowa wanted to speak about what the President has said and what he has not said. What are we discussing here? The views of the President or the actions of the executive? And the actions of the executive, as has been stated, are their prerogative. And clearly, there have been no actions by the government that should be contravened. But more importantly, I believe in the civil liberties of all people and the rights of all people, and I believe that this amendment undermines the rights of all people, and would graciously ask this member to look at it from both the perspective of individual rights, of civil liberties, of the 10th Amendment, and whether or not the executive has done anything that relates to his amendment. I lastly will say that the President of the United States, who commented today, has every right to speak either his conscience, his heart, or his mind. And an amendment on the floor attempting to question that has no relationship to speech today versus actions of which need to be contravened. There are no actions to be contravened, so I ask the gentleman to respectfully withdraw his amendment, and I yield back my time.
The gentlelady yields back. For what reason does the gentleman from California? Gentleman is recognized.
I wasn't going to speak, but I have heard this argument made time and time again that it's the prerogative of the executive branch to decide whether it's going to defend a law legally passed by the Congress and signed by the President. That is hyperbole. That is incorrect. There is an obligation by tradition and by the law that the Attorney General is duty-bound to defend duly constituted laws of the United States so long as he or she can find a constitutional basis for it. It is not the purpose, nor has it been in the past, in Democratic and Republican administrations, for a a Justice Department to arrogate to themselves the responsibility of deciding which laws they like and which laws they did not like. You are supposed to be the attorney for the United States and recognized as such. I recall as Attorney General of California, I was required at times to defend laws that I had voted against, but I could find a constitutional basis for it. And my real problem with this administration is they strain to find any constitutional basis to not defend. That is turning it on its side.
Will the gentleman
yield? I will not yield at this point in time. The point of fact is when the executive branch does not do what they should do, it requires us to make a decision as to whether we should now pay for outside counsel. That has not been the tradition of the United States. And this Justice Department, in my judgment, based on the experience I've had here in this Congress, 18 years, my years as the Chief Legal Officer of the State of California, and 35 or 40 years as a practicing attorney, tells me that this administration has fundamentally failed in its obligation to attempt to faithfully carry out the laws of the United States.
Yield.
Not to wake up every morning and decide, I think I can find an unconstitutional basis for a law passed by the Congress. Think of what that would mean. It would mean that you have an administration in every instance deciding what laws they want and what laws they don't want that are on the books instead of coming here to the Congress and attempting to change what the law is. And if we believe that we have an obligation when we hold up our hands to uphold the Constitution, that means we don't just turn over things to the courts and say, you decide whether it's constitutional. We are duty-bound to pass what we think are constitutional laws, and the administration of whatever stripe is obligated to attempt to defend those laws unless they can't find a constitutional basis for it, not to seek every possible unconstitutional basis so they don't have to defend. That's what the problem is here. And so while I understand many of the arguments made here, and I understand what my friend from Ohio said, and I agree with much of what he said, let's not just say, well, it's the prerogative of the executive branch to decide if they want to defend laws passed by the United States. That has not been the tradition of this country. It has not been the experience. It has not been the legacy of Democratic and Republican administrations going back to the founding of this republic. I'll be happy to yield to the gentlelady.
Distinguished gentleman from California, I'm not sure if he misinterpreted comments that have been made on the floor of the House, but I will just speak to this point. That is too broad a statement to say about the present Department of Justice when every single day lawyers in the Department of Justice, including the Attorney General, go out and defend the laws of this land.
I will take back my time.
And so I'd ask the gentleman to reflect on that broad statement.
I will take my time.
That is not accurate.
The gentleman from California has the time.
Take back my time.
I thank the gentleman for yielding.
I will not accept the gentlelady's argument that I was condemning the actions of those people in the Justice Department who are excellent civil servants. I am specifically talking about the Attorney General of the United States who evidently made the decision, or if he didn't make the decision, failed to make the proper decision to uphold the laws of the United States duly enacted by this Congress. And I yield back to the Council.
The gentleman yields back. The question is on the amendment offered by the gentleman from Kansas. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the ayes have it.
Mr. Chairman, I ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Kansas will be postponed. For what purpose does the gentleman from Georgia rise?
I want to do a amendment at the desk.
I'm sorry.
It's going to take a minute.
The gentleman will suspend.
Sorry.
For what purpose does the gentleman from Michigan rise?
Mr. Speaker, I rise to engage in a colloquy with the esteemed subcommittee chair.
Does the gentleman seek to strike the last word?
I do. I move to strike the last word, Mr. Speaker.
The gentleman will be recognized for 5 minutes.
Thank you, Mr. Speaker. First of all, I wanted to support the inclusion of $47 million in the National Science Foundation Educational and Human Resources account. This is going to really further the effort to help educate Americans in the area of science, technology, engineering, and mathematics. It will help inspire many of our young people to study math and science and then go into these engineering and technology fields as careers. You know, some of the most engaging ways to inspire our young people to study math and science involve informal education settings such as our science centers throughout this country, most notably the Detroit Science Center, which engaged in programs that inspired many inner-city youth and Metro Detroit youth to get involved in education in science and mathematics. So I wanted to thank the chair and the ranking member for including the resources in the National Science Foundation's budget to help provide competitive grants to many organizations such as the Detroit Science Center to help further inspire and engage our young people to study math and science. I mean, we have a lot of jobs available even in Metro Detroit in manufacturing and technology. We just need the people trained in those areas. This effort, this funding, will help encourage many of our young people to enjoy the intellectual stimulation of math and science, and then encourage them to go into careers that are not only fruitful for them, but will help our country's economy become more competitive in the global marketplace. With that, I yield back my time.
Gentleman yields back his time.
Well, I yield.
For what purpose, gentleman?
Mr. Speaker, I yield my time to the gentleman from Virginia.
Okay, I thank the gentleman. I thank the gentleman for his interest in and advocacy for STEM education. I share his belief that STEM education must be a national priority, and I think the more we invest in it is very important for this country, so the 21st century is the American century and not the Chinese century. And I look forward to working with him on this issue as we move forward.
Thank you, Mr. Chair, and I yield back my time.
Gentleman yields back his time. For what purpose, gentleman from Virginia, rise?
Chairman, I move that the committee do now rise.
The question is on the motion that the committee rise. All those in favor say aye. All opposed say no. The ayes have it. The motion is adopted, and accordingly the committee rises.
Mr. Chairman.
Mr. Speaker, the Committee of the Whole House on the State of the Union, having had under consideration H.R. 5326, directs me to report that it has come to no resolution thereon.
The Chair of the Committee of the Whole House on the State of the Union reports that the committee has had under consideration H.R. 5326 and has come to no resolution. For what purpose does the gentleman from Georgia rise?
Mr. Speaker, I send to the desk a privileged report from the Committee on Rules for filing under the rule.
Clerk will report the title.
Report to accompany House Resolution 648, resolution providing for consideration of the bill H.R. 5652 to provide for reconciliation pursuant to Section 201 of the concurrent resolution on the budget for fiscal year 2013.
Refer to the House calendar in order printed. Pursuant to the House Resolution 642 and Rule 18, the Chair 43 in Rule 18, the Chair declares the House and the Committee of the Whole on the State of the Union and under further consideration of H.R. 5326. Will the gentleman from Georgia, Mr. Price, kindly resume the chair?
The House is in the Committee of the Whole House on the State of the Union for further consideration of H.R. 5326, which the clerk will report by title.
A bill making appropriations for the Departments of Commerce and Justice, Science, and related agencies for the fiscal year ending September 30th, 2013, and for other purposes.
When the Committee of the Whole rose earlier today, an amendment offered by the gentleman from Kansas, Mr. Huelskamp, had been disposed of, and the bill had been read through page 101, line 10. Pursuant to Clause 6 of Rule 18, proceedings will now resume on those amendments on which further proceedings were postponed in the following order. On Amendment Number 24 by Mr. Huelskamp of Kansas, on Amendment by Mr. Landry of Louisiana, Amendment Number 32 by Mr. Gardner of Colorado, an amendment by Mr. Rohrabacher of California, Amendment Number 6 by Mr. Lewis of Georgia, An amendment by Mr. Holt of New Jersey. Amendment number 7 by Mr. Kravac of Minnesota. The second amendment by Mr. Flake of Arizona. The third amendment by Mr. Flake of Arizona. The chair will reduce to 2 minutes the time for any electronic vote after the first series of votes. The unfinished business is the request for a recorded vote on the amendment number 24 offered by the gentleman from Kansas, Mr. Hilskamp, on which further proceedings were postponed and on which the ayes prevailed by voice vote. The clerk will redesignate the amendment.
Amendment number 24, printed in the Congressional Record, offered by Mr. Holtzkamp of Kansas.
A recorded vote has been requested. Those in support of the request for a recorded vote will rise and be counted. A sufficient number having arisen, a recorded vote is ordered. Members will record their votes by electronic device. This is a 15-minute vote.
The House continues to work through amendments to the $51 billion Commerce, Justice, and Science spending bill for 2013. It's a 3% cut from this year's allocation. The President suggested a 1% cut and has threatened to veto the bill. These are expected to be the last votes of the day, with a final passage vote tomorrow. President Obama told an ABC interviewer today that he supports gay marriage, the first president to take that position, saying, quote, "At a certain point, I've just concluded that for me personally, it is important for me to go ahead and affirm that I think same-sex couples should be able to get married." This comes on the heels of North Carolina voting yesterday to define marriage as legal only between a man and a woman, the 30th state to approve such legislation. Republican presidential candidate Mitt Romney told supporters in Oklahoma City today that he opposes same-sex marriage